So what is the essential role of court is, if you look at the arbitration law, whether it is UNCITRAL model law or Federal Arbitration Law of UAE or Indian Arbitration Act, for that matter, any jurisdictional arbitration law, if you look at, there they will confine the role of court to play the administrative part only. You know, what is the administrative part? To appoint the arbitrator, you know, even for the setting aside of an arbitration award, the role of court is very, very limited. The court has to act within the specified grounds only. And that grounds also, it is very limited grounds. Okay. So that is what the act says. Now we will see what are the roles the courts are playing in the arbitration life cycle from the beginning up until the enforcement of the award. So initially, even before the arbitration is invoked, even before the arbitrator is appointed, the parties, they may be in urgent interim measure. The very common interim measure is encashment of bonds that you must be encountering in your construction projects. That is very much prevalent throughout the world. The employer, they will, just for anything and everything, they will put their hands on the bonds. Okay. But if you are really aware of your rights and entitlement, and if your contract has arbitration clause, even before invoking the arbitration, even before the appointment of arbitrator, you may approach the court and asking for an interim measure to stop the encashment of bonds. If you are a contractor, then you may demonstrate that the act of the employer is unjustified. If you are able to demonstrate, then the court will issue interim measure. But for getting such interim measure, along with demonstration that encashment of bond is unjustified, the party, the contracting party who is applying for such an interim measure, they must give an undertaking to the court that they will invoke the arbitration within 90 days. So that assurance must be there. Also, suppose if the party gives undertaking that we will invoke the arbitration within 90 days, and they got an interim measure. If they fail to appoint an arbitrator within the set period of 90 days, then that interim measure will be revoked. Okay. And then, okay, before the commencement of arbitration, they can approach the court for urgent interim measure. Then after that, appointment of arbitration, appointment of arbitrator. We have seen more than once, appointment of arbitrator is the prerogative of the parties. It comes under the party autonomy. The arbitration agreement or the arbitration clause, it gives the power to the parties to choose the arbitrator. But most of the cases, what happens? The parties, they don't agree. So in that scenario, they can approach the court to appoint the arbitrator. They may approach the court or they may approach the arbitral institution. It depends upon the jurisdiction. In India, most of the parties, 9 out of 10, they approach the court. They call it a Section 11 application. They have to approach the respective high courts in case of domestic arbitration. And if it is an international arbitration, they have to approach the Supreme Court. And the court will appoint the arbitrator either from their empanelment or at their discretion. Okay. Even before that, Suppose if your contract has arbitration clause, irrespective of that, the other party, he approaches the court for a remedy other than arbitration. Then the opposing party, what they can do, they can approach the court saying that the contract has arbitration clause, therefore the litigation is not permissible. Then the court, what they will do, they will direct the parties to the arbitration. So that is also role of the court. All right, now the arbitrator is appointed, but one of the parties, he finds that the arbitrator is de jure or de facto ineligible. That we have seen in the previous sessions. What is de jure and de facto ineligibility? De jure means by law, the arbitrator is not eligible to act as an arbitrator. De facto means by the facts of the circumstances, he is unable to perform. If the party, if one of the parties, if he finds that, then first he will submit the application to the arbitrator only, because he is the person who can decide that challenge. And if the challenge is not acceptable by the arbitrator, if he rejects the challenge, then the other party, they can approach the court. And if the court, after the adjudication, if they finds the arbitrator is ineligible, they will terminate the arbitrator and they will appoint the replacement arbitrator. Also, during the arbitration proceeding, the court will assist in the evidence taking also. Okay. And then you have setting aside. And once the setting aside is over, enforcement, we will see one by one. So Article 5 of the Ancestral Model Law, what it says about the role of court in the arbitration. So it says extent of judicial intervention, that is extent of court intervention. No judicial authority shall intervene except where so provided in this part. Unless otherwise your contract, it specifies the threshold of the court intervention, then the court shouldn't intervene in the arbitration proceeding. If the contract doesn't specify, then the court role is limited to the administrative role only. Administrative role such as issuing the interim order, which can be revised or revoked by the subsequent arbitrator. Then appointment of arbitrator, termination of arbitrator, setting aside, such kind of administrative job only the court can do. That is what the Ancestral Model Law says. It further says this restricted interference is not with the aim of denying complete judicial intervention. That is what I have mentioned initially. The court has two essential roles. One is the administrative part. The second and most important part is checks and balance, to ensure that the arbitration proceeding is conducted as per the legal requirements, as per the legal compliance. So that is the main role of the courts. That is where the setting aside, it takes importance. So therefore, that is what, Ancestral Model Law, it says, is not with the aim of denying complete judicial intervention. Rather, intention of legislature is to have a limited scope of judicial interference by ensuring there are little options for any party to dispute to knock the doors of the courts so as to ensure finality of the arbitral awards. Okay, so now we will see permitted judicial intervention. What are the permitted judicial intervention? We have seen before commencement of arbitral proceedings. What is the role? Section 8 of the Arbitration Act, it talks about the power of judicial authority to refer parties to arbitration. Okay, when the contract has arbitration clause, in spite of that, if one of the parties approaches the court, then the court's role is refer the parties back to the arbitration. Okay, and then appointment of arbitrator, depending upon the domestic or international nature of the arbitration. Okay, if it is a domestic, then it will be High Court. If it is international case, then the Supreme Court will appoint the arbitrator. Now, a party to the arbitration proceeding may apply to the court to decide on the termination of the mandate of arbitrator that I have just mentioned. When the arbitrator is suffering from any conflict of interest, when he is not acting in a proper manner, when there is an observation of misconduct by the arbitrator, then the parties, they may raise the challenge in front of the arbitrator only. And if the arbitrator does not accept the challenge, then they have the option of approaching the court for the termination of the mandate of the arbitrator. And the court will adjudicate and accordingly will issue the necessary orders. Also, I have mentioned the interim measures. Interim measures right from the beginning or even before the invocation of arbitration, parties, they may approach the court to get the urgent interim measure. I have mentioned about encashment of bonds or guarantees. Okay, now arbitrator is appointed. The proceeding is going on. Parties, they may approach arbitrator also for certain interim measures that we have seen in the previous sessions, for the protection of assets, for inspection. There are certain specified grounds for which parties, they may seek interim measure from the arbitrator. But there are certain interim measures which the arbitrator doesn't have power. What are they? Arbitrator, he cannot make an order to a third party to the arbitration. Arbitrator's power is confined to the parties of the arbitration only. So therefore, if the claimant, if he feels that there is some evidence with a third party, which is material evidence. Material evidence in the sense, with that evidence, the arbitrator can come to a conclusion which is favorable to the claimant. However, he cannot ask the arbitrator to direct the third party to come to the arbitration. So in this case, he may approach the court for an interim order to direct the third party to come to the arbitration. So therefore, the interim order, the court can continue to issue even during the arbitration proceeding also. So that interim order, the power of the court will continue until the enforcement of the award. Even after the arbitrator, he issues the award, the parties, they have the right to approach the court for an interim order until the award is enforced in the court. And that is a powerful tool which the parties can utilize it. Okay. And also during the arbitration proceeding, evidence proceeding, that is a very, very important process in the arbitration. Of course, the conclusion or the decision will be based on the evidence only, isn't it? Whatever pleadings the parties are making, that should be supported with the evidence. And if the evidence is related to a third party, then parties, they may approach court with the permission of the arbitrator, and the court will record the evidence of the third party and they will send it to the arbitrator. Arbitrator, he will include in the arbitration award. Okay, so that is a very important role of the court during the arbitration. Okay, now the arbitration award is made. The losing party, what they will do? They will, of course, challenge the award. And the court now come into play. They will adjudicate based on two categories of grounds. The first category of grounds for setting aside is related to the parties and the arbitrator. What are the grounds? The incapacity of the parties, as explained by my colleague Madhu. The parties' incapacity, they may be suffering from some mental incapacity, and there is no proper notification, proper appointment of arbitrator, misconduct of arbitrator, unequal opportunity to the parties. So these are the grounds related to the parties and the arbitrator. This category of grounds, this is the first category. Then the second category, that gives the discretion to the court itself. So what are the grounds? Number one is when it is against the public policy. When the arbitration award, it contravenes the prevailing laws, statutory laws of the country, then it will be set aside by the court. Second ground comes under the court's discretion is patent illegality. Patent illegality, it deals with the perverse interpretation by the arbitrator. What is a perverse interpretation? It is something based on the factual matrix. Even a common man who doesn't know anything about the law, he cannot come to a conclusion. But the arbitrator, he came to a conclusion. So such kind of conclusion is called a perverse interpretation. So if the court finds there is a perverse interpretation, one example I'm telling you. There is a contract. It says that when certain things happen, or when a certain thing doesn't happen, then the suffering party, he is liable or he is entitled to get X number of amount from the party who caused the injury. So that is what your contract says. But the arbitrator, during the adjudication, what he says, he completely ignores this provision. But he is citing something out of the contract from his personal experience. So such kind of interpretation is not allowed. That is called perverse interpretation. When he is straying out of the contractual boundary, when he ignores something which is present in the contract, or when he ignores certain key evidence submitted by the parties, then it is called perverse interpretation, and that comes under the patent illegality of the decision. So this second category, which gives discretion to the court directly, that acts as the checks and balance for a resilient arbitration award. This is a vital role played by the courts during the arbitration proceeding and after the arbitration proceeding also. Okay, now in another case, what happens? The losing party, he submitted petition for setting aside, and that was rejected by the court. Then what happened? The winning party, he will go for enforcement to realize his money. So that is called Section 36 application in Indian jurisdiction, and in other jurisdiction it is called enforcement of arbitration award. So that is the last point of arbitration. Of course, the very objective of arbitration is realizing the money, isn't it? So that happens in the enforcement. When you submit an enforcement petition to the court, of course, it is an administrative step only. The court, what it should say, it should check the contents of the award. It shouldn't reopen the case. It should check only the content of the award, and it should check the petition submitted by the parties. So during the enforcement, the parties, they will ask two options. First option is attachment of the property equivalent to the award amount. Rarely, they will ask for the arrest of the parties. So these two options are available during the enforcement. So as per the parties' prayer for the remedy, the court will do this administrative step of either attaching the property or arresting the respondent. So this attaching the property, that we must be vigilant. Who is your respondent? In case of UAE, if the respondent is a state entity, you cannot just like that enforce. You cannot go for attachment of public property, unlike in India. In India or elsewhere, once the parties assume the commercial head, once they come into the arbitration, then that immunity is waived by default. Whether it is state entity, it doesn't matter. But whereas we must be careful when we deal with the state entity in UAE or other Middle East jurisdictions which are compatible to each other. So therefore, we must be extra vigilant when we are dealing with the state entities. Of course, there are ways to overcome that. Okay, so we have to adopt the route to navigate such obstacles and properly realizing the money, because that is very important. Otherwise, as my colleague said, the arbitration award will be a mere piece of paper, white elephant. What is the use of having the paper, isn't it? Then appealable orders. There are certain orders issued by the arbitrator. They are appealable. Example is interim order. Interim order issued by the arbitrator that the parties, they can appeal. And then the challenge to the jurisdiction, that also they can appeal. Setting aside under, setting aside or challenging of the award, that also is subject to appeal. Okay, so that comes under appealable order. That also is being dealt by the courts. And we have seen even before commencement of the arbitration, the court can intervene. So this is what the unsettled model laws, it says. The important thing is the ancestral model law, what it says, the provisions of the Arbitration Act, it can override the provisions of the other prevailing acts. Okay. So therefore, if the respondent is citing any other act, quote, what it will say, it will refer to the Arbitration Act and it will say the arbitration provisions that will override the other prevailing act. Okay. So this is a case law. Intervention of court is expressly barred except in situations specifically provided for in the act itself. Role played by the industry judiciary is more of administrative framework. Already I mentioned. Arbitration is not completely aloof from judicial intervention, but it is for the checks and balance. The extent and the role to be played by the courts in arbitral proceeding, it is well stipulated in the landmark judgment. What it says, if it intervenes in pending proceedings, there is bound to be a delay in termination of proceedings. If it does not intervene, the error of moment may earn immunity from correction. So it is simply the checks and balance rule. That is what the Supreme Court it said. Again, the judicial authority, it doesn't confine only with the court. It refers to many roles. It includes authorities, agencies conferred with the judicial powers of the government. Okay. So it is not stopping with the word court. Judicial authority's intervention under the Act is limited to the purposes as described by the Act itself. Nothing more, nothing less. Okay.